Hi everyone, my name is Tatiana Gidirimsky and I'm a family law attorney who has been practicing for 22 years. Today I want to talk to you about what happens when you have a parenting plan in place and one of the parents wants to move with the child. If under your parenting plan you have your child at least 45% of the time and you want to move anywhere outside of the school district, which includes a different city, a different state, or even a different country, you have to follow a certain procedure. And this procedure is governed by the Washington Child Relocation Act. First of all, the law requires you to notify the other parent at least 60 days in advance. And the other parent can object. And if they do object and they file their objection with the court, the case will proceed to trial. The Child Relocation Act has numerous specific requirements regarding the contents of the notice and the contents and timing of the objection. And failure to follow the procedures and requirements may result in contempt of court and other legal consequences. So it's very important to understand the legal requirements for the relocation. Now, for someone who has the children on average more than 55% of the time, under the parenting plan, the law grants a rebuttable presumption in favor of permitting the relocation, meaning it's much easier for them to move with the kids. And in that case, in deciding whether or not to allow the relocation, the court will consider 11 different factors, which are laid out in the statute. And these factors look not only in what would be in the best interest of the child, but also what would be in the best interest of the moving parent. So this presumption and all of these factors means that if the moving parent has a good reason to move, for example, a job at a new location, or they want to reunite with their family, and there are no compelling circumstances that would justify the prevention of the relocation, the court is very likely going to allow the parent to relocate with the child. And as you can imagine, in many circumstances, this is a very difficult situation for the other parent. This situation can be remedied to some extent by changing your parenting plan, by allowing the child to come back to the other parent for school breaks and to spend more time with them in the summer, and maybe to allow the non-moving parent to come and visit the child at the new residence on some weekends. If the moving parent has the child less than 55% of the time, they do not get the presumption in favor of moving, which means that it will be more difficult for them to move. And in deciding whether the move will be allowed in these circumstances, the court looks only at the best interest of the child. And the court, under those circumstances, is not going to care about what's best for the moving parent. So if you're planning to relocate, or if your spouse has informed you that they're planning to relocate, it is very important for you to talk to experienced family law attorney to determine what would be possible in your case and to understand your legal options. So there you have it, the information about moving with the children.